It's my view, a response to the heads of council in the supplementary heads. There's no need to apply for condonation on that aspect. That's a matter for debate. The second issue that I want to address is relating to the firearm that was given back to accused number 2. It was given back to accused number 2 on the day when he was found not guilty. There was a prior agreement between the attorney for accused number 2 via emails that was sent to one another between me and that should accused number 2 be found not guilty, that the firearm would be returned. If he was found guilty, the position would have changed drastically. The issue about the firearm being given back, it's our submission that that is a storm in a teacup. We are fully within our rights. If you read Section 30 of the Criminal Procedure Act, Section 31, which allows us to give the firearm back if there's no need for the firearm to be kept further. If I might read, just to assist counsel, what this particular section says relating to that. Sure. I don't know if it's the lights or what.
I think it's the bright light behind you may cause a glare, I'm not sure.
If you can ask my little colleague, because so I will actually ask counsel to read that particular part for me. You must read section 30 and then section 31, 1, because I can't see. I don't know if it's the light.
Just borrow someone's spectacles that you can see them.
It's time. It's time.
It's time that you go and get spectacles.
Sure.
Oh, he's got them there, look.
Yes, you should.
Sorry.
I got the spectacles.
Now we
It's
we
much
are in a
better.
spectacle.
Much better. Section 30 deals with disposal by a police official of an article after seizure. A police official who seizes any article referred to in Section 20, which we know it's articles which they lawfully are entitled to seize from an accused or a suspect or any person who is suspected to have committed a crime, to whom any such article under the provisions of this chapter delivered may, if the article is perishable, with due regard to the interests of the persons concerned, dispose of the article in such a manner as the circumstances may require, or may, if the article is stolen, property or property suspected to be stolen with the consent of the person from whom it was seized, deliver the articles to the person from whom, in the opinion of such police official, such article was stolen, and shall warn such person to hold such article available for the production at any resultant criminal proceedings if required. I'm not going to read the last one, C. I'm going to go to Section 31, subsection 1A, that deals with this particular issue. If no criminal proceedings are instituted in connection with any article referred to in Section 30C, or if it appears that such article is not required at the trial for purposes of evidence or for purposes of any order of court, the article shall be returned to the person whom it was seized, if such person may lawfully possess such article, or if such person may not lawfully possess such article, to the person who may lawfully possess it. We had no need for that firearm anymore after accused number 2 was acquitted. They didn't need to come and apply or bring an application for the court to make such an order. We did not deem it necessary. It was well after within our rights, after consultation with the investigating officer, that such article be returned and that he be warned that such article may be made available maybe at a later stage. That is exactly what happened. It's my submission that this issue about the firearm being returned is a storm in a teacup, because we were perfectly within our right to return it. The investigating officer has retired. If that article went missing in his absence, it would have caused a greater problem. So that's why the decision was taken to give him the article after he was found not guilty. Ms. Thompson's evidence regarding that particular article, she was not cross-examined because that is evidence that she got from the accused or whoever was informing her that that particular article was given back. It's the same storm in a teacup that was made about the laptop where the video evidence was stolen, despite the fact that it was kept on another hard drive. The laptop was a non-event, so we didn't need to focus on that particular issue. The evidence was still there, it was already collected, just as the article prescribes. Since that issue now has been dealt with, and the law allows us to do so, I want to deal with the issue relating to Section 9 of the Constitution, because that is where everything starts. It guarantees equally before the law and the right to equal protection and benefit of the law. In the context of criminal offenses, the Constitution obliges the court to protect and promote the rights of every individual, ensuring that no person is above the law. I will get to this particular part in a later stage, just to respond to what counsel was referring to about the double-edged sword relating to the accused being treated equally before the law like anybody else, and the fact that we mentioned that he was a public figure and that he should get a more severe sentence than the normal man on the street. Insofar as sentencing was concerned, the court is well aware that courts are obliged to take into account the aim of sentencing, which is retribution, rehabilitation, prevention, and deterrence. The court must consider the personal circumstances of an accused, the seriousness of the offense, and the interest of society. I'm not going to go through my acts page by page, but we have referred to State versus Banda and others.
Sorry, advocacy. So I follow you. Are you doing a combination of the first and second, or which one are you busy with now?
I'm
so
busy with page 2.
Of the first one?
Yes, it's the first one.
Thank
First
you.
one.
Just so I can follow you. Thank you.
Use of the accused's personal circumstances was well articulated by the probation officer, Ms. Thompson. I will deal with the flaws of her evidence when I refer to my supplementary heads of argument. It seems that basically she relies on those factors that the accused did not injure somebody, that he possessed a firearm for a short period of time, and then she made a recommendation because he also have a soup kitchen that he is responsible for, that he should get a non-custodial sentence. I want to add to this point, Your Worship, that I also received the matter, the judgment on sentence of Justice Brooks this morning. I am going to go through it, but I will deal with it briefly, just briefly. the court allows me time to read it properly, I can produce many similar judgments of the same judges in the same division where they differ from opinion, which is within their right to do so. I didn't deem it necessary to hand this particular judgment up by the DJP, the Deputy Judge, now retired Judge President Mdantsane, where he has an opposite view regarding firearms, the matter of, it's an appeal matter, a full bench appeal judgment, the matter of Romeo Jansen, the case number, it's CANR 220/18. I just want to see the date when the judgment was delivered on the 29th of August 2019. This is a full bench matter where he held the exact opposite view of what Justice Brooks held regarding the possession of firearm. And this already outweighed the judgment, as counsel has ended up, of Mr. Nolan Linzima Ndila, because this is a full bench judgment of the same division. I'm going to give counsel a copy as well, if I may hand it up for the court's benefit. Your Worship doesn't even have to be concerned. The fact that that judgment already outweighed this one, which is by a single judge, the court can rest assured, because the Supreme Court of Appeal already dealt with this particular issue relating to firearms. We know that the Supreme Court of Appeal is the highest court, and then the Constitutional Court, the apex court. So the reason why these judgments are relied on by the Supreme Court of Appeal, because of these different judgments from different divisions talking about the same issue, having a total different view. Like I explained earlier, how you can look at the exact same picture and see a different thing. He differs from Judge Brooks, gave a direct imprisonment, quite a substantive one in that Romeo Johnson appeal matter. Your Worship, I want to be upfront that the state is seeking a custodial sentence, and if we can get the maximum sentence of 15 years, counsel correctly said that we do not rely on the Minimum Sentence Act. We do rely on section 121, which refers to the maximum sentence of 15 years. And I'm going to tell the court why we are relying on that particular sentence, or the request to impose at least a 15-year term imprisonment. Your Worship, without being prescriptive, it is correct that the custodial sentence will send out a clear message. Counsel referred earlier about this happen regularly, where people just send fire shots at events, at funerals and so on. I must say, I only saw not saw, but saw it on television once, is the one that was highlighted by the deputy mayor, I think, of the Nice Now George municipality. The outcry because of that shows that that should not be tolerated in a civilized society where people's lives are placed in danger for people who are in a celebratory mood firing shots. And in most cases, these people are unqualified to fire such shots. In this instance, accused did not just fire one shot and left it at that, which we can consider to be an accident. He was malice, to say the least. His actions constituted extreme danger to the 20,000 plus people that were present, not even mentioning the community right around Mdantsane, which we know is one of the biggest locations in South Africa. It's condensed, it's densely populated, and especially on a weekend, it is busy in Mdantsane. It was by the grace of God that nobody got hurt.
If I think I repeated that, I said this on the 23rd of January. If there is such a response, I'm not going to ask you to be quiet. I'll order you to leave. There won't be a choice. Understood? Please interpret, Ms. Margot. You may watch outside if it's going to cause a delay and no noise. Ms. Margot? Advocate Caesar, you may proceed.
Thank you so much, Your Worship. The accused is a political leader. He's got a huge following. Young people emulate this type of behavior. What he doesn't realize is that he already opened a Pandora's box where he creates the impression that this type of conduct is acceptable. What did Pastor Moro do? He grabbed the firearm, ran to a school, screamed it was a toy firearm. Deputy be less than ideal for psychotherapy. But then a prison is primarily an institution of punishment, not a cure. As a court of law was at pains to point, the approach of a sentencing officer is not the same as that of a psychiatrist, and if I might add, also a probation officer or a social worker. The sentencing officer takes into account all the recognized aims of sentencing, including the definition. The psychiatrist is concerned with the diagnosis and rehabilitation. The psychiatrist is concerned to focus on the well-being of an accused at the expense of the other aims of sentencing, so the interest of the community as a restored process and to produce, in all likelihood, a WAP sentence. Now I went to the Oxford Dictionary to try to understand what this word WAP means. It's something twisted, bent, or must have. Something diverted from its original form. It also refers to a distorted it's a guy that's abnormal. I'm getting going for an eye test after this.
Please do.
I've been now for a while. It refers to a distorted, abnormal, or perverse mental state, or sense of humor, or twisted moral values. If the accused get a non-custodial sentence, but this is basically what a law now would go to. It will tell people that it's okay that if you find yourself, whether it's 1 or 2 or 10 or 15 or 22, it's fine, you'll just get a fine, non-custodial sentence, because this is what the type of sentences the courts are imposed. Whereas it's my submission, everything that we needed to know. No witness would have been able to describe everything that we saw on that video. To rely on the fact that no witness came and so on is neither here or there, or that we did not call any witnesses in aggravation of sentences, either neither or that. The video speaks for itself. They say a picture speaks 1,000 words. This is one of the instances. I always have an issue when I see words like obnoxious and so on. I like to consult the dictionary to understand what is this person trying to say when he uses words like that. The word in this obnoxious, in this context, is meant not harmful injuries. It describes something safe, inoffensive, or unlikely to cause disapproval. Often refers to remarks, behaviors, or substances that seem harmless, but may not be. Synonyms include harmless, safe, innocent, inoffensive. We know for a fact that this firearm was not fired. Both of them were not fired innocently. This accused he planned it. And when asked why did you choose a particular direction to fire, he says, don't tell me how to fire a shot. I can fire it even from underneath the stage if I feel to do so. It is not innocent. His intention was clear. He was going to do whatever he wanted to do, regardless of the circumstances and the situation and the danger it might have posed to the people around him. It was on the video, it was clear people were running. He disputed it until the last minute, but the evidence was there. We've seen it. There were 7 people in the direction, 20,000 right around where he was standing. For him to rely on the police that did not charge him and all that, that's an issue that needs to be dealt with by the police themselves in their internal investigations. I've already highlighted to this court why I referred to the Malpas case. And just to be clear that it is against this background that sentencing for firearm-related offenses in terms of the minimum sentence return must also be viewed. The question arises as to whether a standardized and consistent result, as was envisaged by the Malpas case, has indeed been achieved in respect of sentencing for the possession of semi-automatic firearms. We know that this one was an assault rifle, despite it being semi-automatic. Its size of the ammunition is dangerous. It's bigger, it's more powerful, and could have had fatal consequences. So the Supreme Court of Appeals referred to the tendency of the courts to use, even only as a starting point, historical sentencing patterns as a provisional standard for comparison when deciding whether a prescribed sentence should be regarded as unjust. Again, like I said earlier, it's neither whether it's a minimum sentence that's applicable or maximum sentence, a standardized approach to sentences for certain offenses. I've referred to all the judgments that counsel assisted me, Mdantsane, Asma, Mdantsane, Sibanda, Dada, Lahi, Fatwe, Giorgio, Tau, Mukovo, judgment is closer, in my view, to more or less the same similar circumstances, not a firing. I don't want to be misunderstood when counsel reply. It's not a firing of the shots for celebratory purposes and so on. I don't want to be misunderstood. But what I understand, what I want to point out, these people did not have the firearm for long periods of time. I have referred to it in my cross-examination of Ms. Thompson in the matter of State versus SWAT, where the appellant was convicted on 2 counts of unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on one of the counts in view of the fact that the appellant reported a denial of possession, which the denial was found to be false, which is the same as this instance. He said he had a firearm, he said it's a toy. He still maintains it's a toy, regardless of the evidence, already overwhelming evidence proving otherwise, that this was indeed a real firearm owned by the owner, which we gave the firearm back to, which was ballistically legal. Back to after he was found not guilty and discharged. And furthermore, that no mitigating circumstance in relation to his possession could be inferred. The court held in the SWAT case that there was nothing to place in unlawful possession of the firearm in a less heinous light, and that which motivated the lawmaker to lay down a minimum sentence of 15 years. However, a further count of unlawful possession of a semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. This gentleman had 2 firearms. Ms. Thompson testified, said, yeah, well, 2 firearms, not taking into consideration, even when it was pointed out to her that the accused fired with 2 different caliber firearms, which he denied that he knew that the one was smaller or bigger, something that was so obvious to see. I don't know firearms well, but you know one is a rifle, the big one, and one is small, it's a heavy gun. In this regard, the court held that the state accepted the appellant's version to the effect that he cautiously came across the firearm in a rubbish dump and was apprehended the same day. Here, Ms. Thompson was saying, yeah, we didn't know how long did he have it, and all the fact of the matter is a day has got 24 hours in it, and he was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made in the spur of the moment. Furthermore, it was held that the appellant did not have the firearm in his possession for very long before he was apprehended. He didn't have it long. Same as was reviewed by Ms. Thompson, yet this is the sentence the appellant was given. One was 15 years in respect of the one firearm, then on the other firearm, the sentence was reduced to one, my memory serves me correctly, of 7 years in prison. The court held that in the circumstances of the crime was such as to make a sentence of 15 years imprisonment as proportional. That was the one that he did not have for a long time. The other one, we didn't know how long he had the firearm in his possession. What I want to point out in this particular matter is not said whether he fired shots with this particular firearm or not, or whether he used it in the commission of further offenses. the impression is created that if you have a firearm in your possession, you should commit other serious offenses for you to qualify for a 50-year imprisonment, which is not the intention of the legislator. That's why the Firearms Control Act was enacted, because of the seriousness, and the Parliament deemed it necessary, the legislature deemed it necessary to make a specific act for firearms because of the serious nature that it poses. The legislator did that in order to single it out for harsh punishment. You are already guided by the cases in the Supreme Court of Appeal. You don't need to really consider all the other cases, whereas there's already authority from the Supreme Court of Appeal saying that harsh punishment should be imposed. In both Mdantsane and Reply, Supreme Court of Appeal upheld the minimum sentence for the possession of semi-automatic firearms. So in cases where an accused is convicted of a standalone offense of unlawful possession of a semi-automatic, the courts are taking an increasingly unsympathetic stance towards offenders, and terms of imprisonment with a range of 7 to 10 years imprisonment are commonly imposed. In addition, the accused's personal circumstances, one of the most important factors in deciding an appropriate sentence, is his explanation as to how the unlawful possession came about. What did he say? He's planned it all along, even the EFF planned this all along, that this is what they're going to do for show, to entertain the crowd, not taking into consideration the consequences it might have caused. And it's no wonder the accused went right to the right side of that stage, firing those rifles, realizing there's only a minimum of 7 people that were standing there. It seems that the judicial sentiment increasingly does not support the view that possession of an unlicensed firearm should be treated as serious only if the weapon has been used in the commission of the offense. And in this case, we know for a fact that he did not, he used it. He was found guilty of all the other alternative counts, or the other counts, because he has used them. He was charged for them, and he was convicted of those offenses. I've already alluded to the fact that there were so many people there, and the danger that the accused posed to that community, the supporters. Therefore, the state prays for the maximum sentence of 15 years imprisonment in light of these aggravating circumstances and factors that are already pointed out to the court. Without being prescriptive, respect of count 3, 4, and 5, the state will submit that fines may be imposed on those sentences and will not impose such type of sentence, and that we say it's because of what it's in a single event, different counts arising from one single intent, that these sentences may run concurrently. I know counsel said this already when he read my ex paragraph 47 on page 30 as I was concluding that the accused have treated this proceeding with such contempt. He took the citizens of South Africa for fools when he tried to convince everybody that he fired the toy gun. Everybody can see that it's not a toy gun. He blamed everybody for his actions. He confused the law with politics. He practiced all intimidating tactics by hiding behind crowds. Dragged us to be participants in this show. It's time for this court to tell you that this show is over. The court must send out a strong message to other offenders who fire shots amongst crowds and endangering the lives of others, that if you do commit the crime, you will do the time. Counsel refers to the supplementary as a repetition. I did point out that the authority of the counsel refers to other than the one that he gave us this morning. That Mahoniana versus the EFF, the speaker, for a broad constitutional proposition about value of liberty and the role of the court. I submit that these authorities are entirely inapplicable to the present sentencing inquiry. It's not applicable if used for the death penalty. We are not seeking the death penalty. Its ratio has no application to the imposition of a proportionate custodial sentence for serious firearms offenses. It doesn't even relate to firearms. It concerns a constitutional crisis involving Parliament, observations about the rule of the courts as a stabilizing force support the state's position. Courts must uphold the rule of law and the principle of equal treatment. Mr. Swartz was sent to prison. Another gentleman I referred to also was sent to prison. How fair will that be? Will that be a consistent, standardized approach? If a non-custodial sentence, what must Mr. Swartz think when he hears or sees that he accused because of his standing in society, the fact that he's famous, that he did not get a custodial sentence like the ordinary man on the street? It's my submission that will be really a discrimination against the poor in favor of those powerful. So where it affirms the constitutional value of individual liberty, the state does not seek to ignore that value. It submits that liberty, properly understood, must be balanced against the rights of 20,000 persons whose safety was deliberately imperiled, and against the rights of society to equal and consistent application of the criminal law. Counsel said that I asked one thing and then I referred to another thing. That's why I specifically said above 7 years and up, it's because of his position and the precedents that he created by doing such. Into the case of Pretorius was never charged for being in possession of a firearm. He was charged for discharging a firearm in a restaurant of 200 people. He was charged with unlawful possession of ammunition and not possession of firearm. For the defense to rely on that issue for the firearm related offense, it's displaced. Because that issue, he was imposed that type of sentence for that discharge in the restaurant. If you multiply, I don't know how my accounts are. That was 100 times more. In this case, Pretorius fired, shot accidentally, and he was imposed a suspended sentence. In contrast with the accused who fired, according to him, deliberately so, says he can fire anyway if he deems fit. Here this man was apologetic because he knew he was not supposed to do that. In this case, the accused says, I can do as I please, don't tell me how to make up my mind. So the 200 people that were multiplied that by 100, then we'll get to 20,000 people. That's how serious this was. Was the Pretorius 200? He accused fired 20,000 people plus, excluding the community around in Mdantsane area. So the aggravating factors, just to conclude, that the court must consider the degree of premeditation, the lack of remorse, the inadequacy of Ms. Thompson's evidence. She spent 5 hours assessing the accused, and I'm not talking about 5 consecutive hours that she can at least get an idea who the person is she's dealing with. She speaks about an hour and a half here, an hour there, and 2 hours there, on different dates, different times. She was just basically there to do a job, just to compile a report for the purposes of these proceedings, but did not compile it to assist this court to come to the correct decision. She was biased in her assessment. Basically, she was employed by the accused to come and bring that report because she was paid for it. His absence of remorse, insight, and accountability. Until today, he still doesn't see what he did, what danger it posed, and what the consequences could have been. His position as a public leader and a role model to the young and to society. The fact that he's a lawmaker, breaking the law. The fact that 2 firearms were used and live munitions were fired, not once, like in Oscar Pretorius, not twice, but multiple times. The degree of premeditation involved, court imposed a custodial sentence, it will satisfy the principles as set out in State versus Z. And the court will do its constitutional mandate of equal treatment before the law and will serve the legitimate and pressing interest of a society that has the right to expect that its leaders and lawmakers be subjected and to obey the same law that they are elected to uphold. That's my submission, and that's anything else for the one to do.
Thank you, Advocate Caesar. With you now. I just want to get the charge sheet and endorse. I'll be with you now, Advocate Ntluphatoke.
Firearm to Mr. Malema. That part was inconclusive, and that's was the reason why Mr. Slayman was acquitted.
And the floor is yours. Thank you.
Points to reply to.
Yes.
The first one is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. Firstly, your leadership wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson at paragraph 50.4, where she says, it appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from the Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supplying or transferring the firearm to the accused. And this is the crucial part. And the rifle was shown, that was shown in court, was returned to Tactical Security Services before judgment was delivered in this trial. That's the first part of the source. Then, if you then go to the transcript of the evidence of Ms. Thompson at page 35. Line 8. She says, however, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services actually inapplicable in the current circumstances because it deals with disposal by police officials of articles after seizure. It doesn't deal with articles that are part and parcel of the criminal proceedings themselves. Similarly, Section 31, which is another section that was relied upon by Mdantsane, refers to disposal of articles where no criminal proceedings are instituted or where the article is not required for criminal proceedings. So we know in relation to the first requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings. So it also does not apply. What does apply are the two sections that were not referred to by Mdantsane, which is Section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles After Commencement of Criminal Proceedings, which is where we are. The criminal proceedings have commenced. The article is a piece of the evidence that can be used to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this Act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in Section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your leadership to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It's not up to the state. Why that is important is also Section 35, which is another section that was not relied upon by the state. That deals with the forfeiture. So your leadership will know under Section 34 you may order the item to be returned, but under Section 35 you may order the item forfeited to the state as well. Because under Section 35 subsection 1, it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed, or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this Act, forfeited to the state. So what happened here is that the prosecutors on their own showing agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you are acquitted, you may come and collect the firearm. Whereas the provision in Section 34 says the judge or the magistrate, whoever is presiding, may make that. It raises profound questions, my lady, with the greatest of respect. The first is, how does the accused know that he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment upon the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced. And that is in the context where a witness has given evidence. It is correct, as Mdantsane points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they had this email chain, you would expect that on the day the witness gives evidence, they put it to her. But they don't. And then they try to get that evidence introduced in argument, which your leadership can just dismiss without more. So we submit, therefore, your leadership, that there is a potential irregularity which flows from the non-compliance with Section 34 of the Criminal Procedure Act and the non-compliance potentially with Section 35 of the Criminal Procedure Act. But we say it also raises really profound questions about how how this knowledge occurred prior to the delivery of the judgment. We leave it there and take it no further, but we say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. We say it's relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the propriety of the conduct of the state. The second question I want to address then is to look closely at why does the state say Mr. Malema should go to jail? This is clearer because the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary heads because there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated. But it seems that they actually misread the evidence because the planning that Mr. Malema talks about, if you look at the supplementary heads of argument, the leadership will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense. He's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they have planted words in their heads of argument, and then they've imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event. That actually cases of planning and premeditation of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your leadership, you'll see from our heads of argument. What the second conviction is about 1 bullet. It's 1 bullet, not the 22 bullets, 1 bullet. So ordinary cases of premeditation do not have that element, because what you find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they return the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, your ladyship can discard that without more. So that's item 2. So we say your ladyship can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about 1 bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your ladyship goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were, but what the court said the findings were. And the important ones is 1.2, unlawful possession of ammunition in contravention with Section 90 of the Firearms Control Act, to wit. Now those words, to wit, usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. a .223 Remington bullet, one bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export, or in transit license or other authorization. 1.3, unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady, with the greatest of respect, that the findings are distorted. It's a narrative building. Yes, and my learned friend also points me to even the first finding is unlawful possession of a firearm. Not the firearms, a firearm, one bullet. So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. You can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2. 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. So it's like a game that they're playing. It's a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader and a role model. Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So in other words, my lady, what we have is that for the state that chops and changes its case, depending on what it wants to achieve at a particular point in time. Today, they are trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentarian. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had the propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC? And the fact that, my ladies, the fourth part of it, is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There is only one punishment as far as that concerned, it's custodial. So what we say, my ladies, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately is a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of their heads of argument. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says, after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you've said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of argument. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your ladyship cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, it described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution of Mr. Malema.
On which ones? Supplementary or the first one? 18B.
So there they say, Mr. Malema complains of the political vendetta by AfriForum. That's the point I'm addressing. Leadership doesn't want me to refer to AfriForum, that's fine.
No. Sorry, Advocate Nklukaitobi. I'm just quickly reading what you are referring me to before saying that I don't want you to say it. Let me just read the paragraph quickly. Okay. Advocate Nklukaitobi, I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding, but you may proceed. I'm noting what you are saying.
The lady, it is the state that says that Mr. Malema lacks remorse because he has blamed AfriForum. I'm simply explaining.
And the Holy Spirit, including
I'm not dealing with the Holy Spirit, I'm dealing with AfriForum.
Please leave. I've spoken, so I was very clear that there'll be no choice. So I don't know how we are going to approach this. It's distracting to counsel for the accused. It's distracting to the state and to the court. And I do not need your approval of yes and no, because I'm independent. I don't mind yes or no at all. So do you leave or what? Because I'm not going to tolerate it. So there's a whoever wants to comment, please leave. Whoever is commenting now, please leave. And from now on, I will leave that in the hands of SAPS. Whoever comments or speaks, ask them to leave, please, because I'm concentrating on what counsel is saying to court. Sorry for that.
Let me just give one sentence on AfriForum, because I think that's what is increasing the temperature inside.
I'm listening.
Mr. Malema is entitled to regard AfriForum as a political adversary and to criticize it for an unfair prosecution because he believes that they are behind his prosecution. What you cannot do, you cannot take that political statement by Mr. Malema and take it to account in sentence.
I hear you fully, yes.
Thank you, ma'am. Then they are also complaining that he has complained of racism. Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism? It makes no sense to me at all.
Okay, I'm not going to respond, but I'm listening, yes.
No, I'm not asking your leadership to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against? Why would they have an issue with that? And why would your leadership be required to put that in your judgment, in sentencing? Now, the last one is the Holy Spirit. Nothing is to be said about that. Then C is showing no insight to the danger of 20,000 people. But if you look at closely, it is precisely the same point as Roman figure 2. Nothing is added by putting it here. Then D. He has sought throughout to conflate the rule of law with political persecution, undermining public confidence in the administration of justice. Now, it's unclear what are the facts on which they rely here. Why do they accuse him of undermining public confidence in the administration of justice? What did he actually do? Because, my lady, people that undermine confidence in the administration of justice, you know what they do? They don't come to court at all. They shout at the court from outside, and then they are ultimately found guilty of contempt of court for not showing up. Mr. Malema has been exemplary throughout the trial. He has been truly exemplary. If he's told to come on the 9th, to the 20th, he's here on the 9th to the 20th. Come at 8:30, he's here at 8:30. He has never once missed a beat. When he had to give evidence, obviously his personality came through, as you heard from the witness, who said he does have a combative style of speaking. But having a combative style of speaking should not be conflated with disrespect of the judicial process. So we would submit to your leadership that you cannot take this factor into account. There's just no evidence that Mr. Malema ever acted in a manner that shows disrespect to the proper administration of justice. This is particularly so when the prosecutors are not confident enough to pinpoint the specific evidence on which they rely for saying he has undermined the administration of justice. And then, my lady, here's the point I was making earlier, paragraph 19. Critically, The probation officer, Ms. Thompson, herself acknowledged that the accused continues to assert his innocence. So, this is the point, my lady. After conviction, the accused says, I'm innocent. Now the state says, take that into account against the accused. He will say he's innocent until the constitutional court says you are guilty, at which point he will then accept that perhaps I'm the only one who believes I'm innocent and everyone else thinks I'm guilty. But the mere fact that at this stage he is asserting his innocence is not a factor that counts against him. But if you did that, you then violate Section 35 of the Constitution that gives you the right to appeal. The last point, my lady, is to correct some legal misconceptions. Your ladyship has been given this case, Mdantsane versus the state, by Fansei DJP. My lady, this case is unhelpful to you. This case is about someone with previous convictions. It is a case where minimum sentencing legislation applies. And it is a case, if you look at paragraph 2 of the judgment, where it says the appellant produced the firearm, Robbenheimer ran away, and he heard the sounds of gunshots. The appellant was known to him as being a member of a gang called the Fat Cats. It's a case of gangsters. It's not a case of a politician in a temporary lapse shoots a firearm to the sky. This is a case of proper gangsters. There is absolutely no basis why the prosecutor says you should read this judgment. It will help you, because it will not help you. Then, my lady, you have a collection of cases. And again, this is another misconception. We've cited, and I will ask your ladyship when you retire to have regard to this judgment. In paragraph 31 of our heads of argument, we've done precisely what the state says we didn't do, which is to separate cases of possession from cases of discharge, and to look at the patterns of sentencing for possession versus the patterns of sentencing for discharge. What we find at paragraph 31, and this is all set out very usefully in the judgment of Cluster J, S versus Mdantsane, where he refers to, I think at that point, all sentences that he was aware of on possession. So, you see, S versus Malema, the sentence that it was an automatic firearm, not semi-automatic, automatic. The sentence was, there was a direct imprisonment. On appeal, it was altered to 2,000 hours of periodic imprisonment. S versus Zondi, where there was a conviction and a direct imprisonment, but converted to a fine of 2,000 rands or 18 months imprisonment. And then the last one that would be relevant for our purposes is S versus Limo, which is the last of those cases. Initially 18 months, and then ultimately converted to 6 months, fully suspended. Those are possession cases, possession. And then we then deal with discharge cases, which we start dealing with at paragraph 35. S versus Fayoum, S versus Pistorius, Munsami, and another, and the Bada versus S, paragraph 41. Yes. 4 judgments. What the pattern appears to be, my lady, is that almost invariably, in discharge cases where there's no harm, no direct imprisonment is ever ordered. Pure discharge. No direct imprisonment is ever ordered. All of the cases we found, discharge the firearm in the sky. I mean, Julius' case was actually a paradigmatic one, because it's actually in an enclosed room. It's like here in the court, the place is full of people, and then Oscar shoots the firearm. It's not his firearm, someone else shoots it to the roof. And then they say 3 years fully suspended. Don't go to prison. So the pattern on discharges when no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I accept what my learned friend says, that there are cases you will find of 7 years. But virtually every case we've looked at that they have cited always involves, like this one we've looked at, gangsters or some sort of other offense that is the possession is part and parcel thereof. Not one case involves an instance which is what we describe as a fleeting possession. Somebody comes in, take this firearm, shoot it aside the crowd, bring it back to me. Never found a case like that. So it is not correct for my learned friends to ultimately come to the conclusion that the pattern of sentencing in possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So, my lady, what you have, you really have a wide canvas. A wide canvas that starts from fully suspended, mixed suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state of the law. And we have shown in this case the unique facts that were pleaded by Ms. Thompson. My learned friend can complain about Ms. Thompson's bias, etc., but the fact of the matter is there's only one witness on sentences, one witness. The state could have controverted that by bringing their own witness. They never did so. So, my lady, we come back then to the beginning. We ask for a non-custodial sentence. But the nature of that non-custodial sentence is in your ladyship discretion. What we simply say is that it will be contrary to the law. Not because we like Mr. Malema or anything. It will be contrary to the law to send him to prison. Thank you, Madam.
Thank you, Advocate Nkosi. Thank you. There's no provision for you to reply, Advocate Caesar. This is it. The defense, am I going to indulge him? It's not procedure. He's trying, he wants to rise, so you may outvote him. Okay, the extra point I disregard, but with the rest, we stick to procedure. Is it a new point? What you want is not raise the point, but on what is the basis of you wanting to do so, that I can listen to and then I can tell you yes or no.
No, you should always just going to advise counsel to read section 30 and 34.
No, okay. That is a no. All right. Thank you, Advocate Caesar. All right. So that is us for the day.
Since no one is speaking to your leadership when you ask me, that is it. The one thing we agree with the state on is that we need to get finished with this.
Yes.
If your leadership is ready with a judgment this afternoon, we would appreciate it.
Advocate Nkosi, let me be very clear and maybe indulge not in a because I'm not ready. The aspect of sentence today is still to be decided. Let me explain so that everyone, and I'm sure I do not have to explain, you are all senior officials and very much aware of what I'm about to say. What you read on paper materializes when it's said loud in court. The impact, the tone is not reflected on paper. It's heard and experienced when you are in court. So the actual sentence, yes, must be determined. Having done the groundwork and the summaries, that has all been done. But to say proceed when I've just heard a whole lot of additional information, I have to structure and
I have absolutely no problem. Your Lordship is adjourning us to a date to be advised.
No, we've got 2 days, and I intend to do our utmost to reach our end goal. I just don't want to say and commit after I've explained why, and you all know, when you read and when someone says, it's a different, totally different impact when you hear and when you read in your office. It's then you go back, as you say, you retire, not yet though, and you combine the two. So that is what I intend doing this afternoon. So we can, sorry, I see I'm keeping you on your feet, but you are free to take a seat. I can go to the extent of, just so that we don't waste time at 9 a.m., to place the counts and the penalty clauses and the minimum, the formalities on record, because that's not something I have to prepare. It's a fact before all of us, but I need to place it on record. I can do that. Or we can say 9 a.m., but I'm not going to go beyond that. So
Lady, we are just in your hands.
I think it's inconvenient for everyone for me to come back. I will ask you, and maybe you can, Advocate Otis, Caesar, your client. I'm thinking of all the media stations and such to return for me to read out a formality which is known to all, or come back at 9 a.m. But I intend, as I say, not to go beyond and for us to reach our goal as planned.
At 9 a.m. tomorrow.
Then your word is my command. Agree, Advocate Caesar? All defense? All right. Mr. Malema, just a minute, please, gentlemen. The court is not adjourned yet. We are still busy. For the reasons I've mentioned then, and for us to, or for the court to proceed or commence with sentence, and hoping that we will reach the finality of this matter tomorrow for anything that may follow. Tomorrow, I would assume it is the same venue, but I'm also directed by the management. I assume it's the same, 8:30, for us to start at 9 a.m. I'm sure the same venue, which is High Court venue. Okay. Thank you. Court will adjourn. Stop.